I don't know if you're the same way, but I always thought of myself as like, I'm a very healthy person. I'm like very resistant to disease. I don't get sick. It's not what I do. And like, brother, I was wrong. I am very susceptible to daycare, to like little daycare super bugs.
It's funny because the minute you say it is the minute it'll happen. I used to say it
Mhm.
all the time, like I never get the flu in the winter, and then every time I said it, it would happen.
Yeah. Well, didn't they say that something there was like a 90% reduction or like 95% reduction in flu cases last year because of the pandemic?
That does not surprise me at all. And honestly, I'm also one of those people who tends to diagnose myself, which I probably should not be doing, especially in a pandemic. So if I sneeze in my head, I'll be like, well, let me Google it and see what that means.
Yeah. Anytime I wake up and like my head hurts a little, or like I have a like I cough once, I'm like, that's it, it's all over.
I know. And honestly, I can only imagine that as a parent, if you've got a child who like happens to cough while he's in daycare,
Mhm.
good luck. That child's
Yeah,
coming home.
at least with the kids in the daycare, like you know that like your 1 year old isn't getting COVID. Like they just don't get COVID. So, but what you know instead is that like they're gonna come home, like one day they're gonna have a runny nose, and then they're gonna be sick, and the daycare is gonna say like, I have to keep them home and until they get a COVID test. And you have to get them a COVID test, and then like 3 days later you can bring them back to daycare, and then you and your spouse are sick for another week after that.
Oh, the joys of parenting.
Great. It's real great. It is really great, except for this one thing.
So how are you feeling with that pink eye?
I put drops in it, and the drops seem to help a bit. I have like some other just like mild cold like symptoms, which are not fun, but I'm, being a professional about it. Um, the biggest thing is that you're really not supposed to touch your eye if you can avoid it. And I don't know if like my eye is just extra itchy because of the infection, or I just underrate like how much I like just like absent-mindedly like touch over my eye during the day, but it feels like I feel like my hands are tied behind my back. It feels real crazy not being able to just like touch your eye absent-mindedly.
I don't know if I ever shared the story of how I came to join this firm, but I do credit it on me getting the chicken pox as an adult, right in the middle of all the interviews for articling positions. And yeah, so I can relate to you and how frustrating it can be at this stage of life to get something like this. But
Yeah,
yeah,
yeah.
that's funny.
I I went to summer camp for like 11 years when I was young, and I never got pink eye at summer camp. And like everybody gets pink eye at summer camp. I had to wait until I was 36 and working at home all day
Yep.
to come down with it.
It's funny.
Yeah. How are things going at the new place, all in all?
Yeah, I guess if you guys will notice, I'm in a very boring space right now. I just moved to a new place. I'm gonna say it's been 2 weeks since I've been living here and haven't had a chance to even empty out a box. So it's gonna look like this for a couple more weeks, I think. How's your move been? I know you've moved recently as well, right?
Yeah, it's been okay. Like what can I say? It's the place is more or less together. I've taken, as you can see behind me, I've taken like one painting up off the floor and like put it
Still
on
impressive.
the Um, well, it's funny. Like before this, we were in our two-bedroom apartment, and basically up until this point, we've actually unpacked and set up about 2 bedrooms plus the kitchen plus the living room of the new place. So we're roughly occupying the same amount of space in our new house as we were in our old two-bedroom apartment. There are two rooms that are still just upstairs that are still full of boxes. Like the basement looks like a spooky underground parking garage at night.
You guys
It's
have
like,
still done more than I've done. I've set up, when I first moved out of my old place, I sold off all my furniture. I stored it at my sister's place, and it just looked so good there that I didn't have the heart to ask for it back. So now I've got basically my parents' old furniture, whatever they could like figure to give me. So an old desk, an old couch, and mattresses. That's it. So it's been interesting.
what's on your furniture wish lists right now?
Oh, I saw this beautiful sectional that I cannot justify paying for, but it's so pretty and it's white, which I know is like the worst idea in life, but I think I still want it. What about you guys? Are you buying new furniture?
We really want a sectional also, I have to confess.
I will be sending you pictures after this.
I can't wait. Yeah, besides that, we need some stuff for our home office. We're still working on the dining room table. I'm sitting at the dining room table right now. We still need to buy some desks and a chair. I was not ready for how expensive office chairs are.
Yep.
Like, holy smokes.
So for Father's Day this year, I redid my dad's home office, and I really did it for me because I was staying with them for a while. And now that I've left, I kind of sneakily took the computer chair with me because I didn't want to buy one of my own. So if he's watching this, he's not going to be very happy with me.
Yeah, I in my mind, I know how much I sit on it. I know how much a good chair is good for my posture and my lower back, but I really have a hard time justifying paying the amounts of money that they want for this. For some, like in my mind, I still keep thinking to myself, it's just a desk chair. How could it cost this much for just an office chair? And I know that that's not true, but I can't get over the psychological hurdle of I can't get over the psychological hurdle of like paying $600 or more for something that is the cousin of a chair that I used to sit in when I had a cubicle.
You know what we're doing here? We are adulting. I know that sounds a little corny, but I had to say it.
Buying desk chairs, finding sectionals.
Well, on that note, maybe we should get started for today.
Okay, let's go.
Join us for Legally Adulting.
Adulting is not supposed to be easy.
What are the questions and concerns that we as young people have about living through a pandemic?
Hi, everyone. Thank you for joining us for Legally Adulting.
Great to see you all here on our spookily adulting Halloween legal spooktacular. I'm just kidding. It's not.
I like that. That was actually pretty good.
Sorry.
Well, thank you. As most of you probably know, I'm Simran Bakshi, and I've got Paul Adam with me.
Hey, everyone.
We are hosting, I cannot even keep track of how many we've done already, but our Legally Adulting program, which we've been doing for, I'm going to say 2 years now.
Yeah, feels like it.
Paul and I we always have the chance to catch up on these things ever since the pandemic started. And I find that whenever we're talking, it's like a perfect example of adulting. Like the things we talk about now are not what we would be talking about, 10 years ago. Mm-hmm. And that's kind of why we started this program. We really wanted to have a platform for just young professionals, young people to express and talk about the things that are just keeping you up at night and, how a lawyer fits into that equation.
Yeah, the idea that brought us to Legally Adulting was that And I think this is a phenomenon that every generation feels in its own time, that the pressures of having to carry on a supposedly adult life are just too much for one person to cope with at all times. And at best, you can sort of keep the basics, like keeping food in the fridge and keeping the floor swept and not getting fired at your job on the front burner. Taking the baby to daycare every day, in my case, on a day-to-day, week-to-week basis. And there are so many bigger picture concerns that you never really get around to solving by yourself, where you feel that you don't have the tools to solve by yourself. And Legally Adulting started out as a forum for people to meet in person, so that our friends, our neighbors, our sometimes future clients could connect with other adults who could help take some of that pressure off of your back and take some of those agenda items off your plate that you would never have the wherewithal or the time to solve by yourself. Lawyers being one of them.
And it's interesting because now with the pandemic, it's almost become a platform for us all to express just what's, the things that we're thinking about, the questions that we have. We might not have the answers, but it's a platform to kind of share our thoughts on this, where the courts are right now. I think we're all kind of learning how to direct ourselves through this as we go along. And it's been a really great way to kind of continue to connect.
Yeah, and as much as Legally Adulting is a forum for our friends, our audience to connect with us, it's also an important forum, I think, for Simran, you and I, to connect with people and find out, a year and a half ago, Legally Adulting was about everybody's concerns about the pandemic being upon us. And now I find it very interesting to field questions about how we'll adapt to the pandemic ending someday and people going back to work, people resuming the rhythms of adult life that they had before this all started. And Legally Adulting has always been a forum for us to keep our ears to the ground and find out what the streets are talking about.
Yeah, and like our objective with this program has always been to keep it very tailored to what you guys want to be hearing from us. And we're really grateful for all the questions that have come through. So our agenda today is to really address these questions. There's a lot of questions about COVID-19, as I think we'll have those questions for a while, unfortunately, but a lot more about, as like Paul was saying, returning to the workplace and vaccines and just what rights and obligations are surrounding that. We also had some really interesting questions about estates, aging parents, what to consider, best practices that we'll get to as well. And then Paul and I thought we'd also get into kind of sharing stories from our own practice and what we often hear about from our friends and family. And if there's any other questions you guys have along the way, by all means, just type it out in the chat function. We'll do our best to get to them as well.
Can my employer terminate me for cause if I refuse to get vaccinated for COVID-19?
That is the question on so many people's minds. And you're going to hate me for this answer, but we don't know enough just yet. It really is going to depend on circumstance. I don't want to make this too technical, but in Ontario, generally speaking, if an employer lets you go, if they don't have proper legal cause to do that, they do need to pay you or give you notice of that termination. That's where the entire concept of a severance package comes from. Now, the exception to that is where an employer lets you go for a just cause. And when that happens, it's kind of a two-tiered system. Our Employment Law Act says if the employer has let you go because you've engaged in willful misconduct, then because there's legal cause, they don't have to pay you anything because the misconduct is what's led to that termination. We've got a common law concept of just cause that says it doesn't even just have to be willful misconduct. It could be, consistently being insubordinate or, you know, having issues with your performance, and that in itself is enough for cause. But if you have common law cause, you still get at least your minimum ESA entitlements. So it's a little confusing because you've got two different levels of entitlement. But where COVID comes into place with this is if you are saying, I'm not coming back, I'm not getting vaccinated, I know you've got a policy, but I just don't want to do it for whatever reason, is that going to be considered legal cause where you may not get your severance package, or at least not very much in terms of a severance package? And it really depends on, I guess, your employment history as a starting point. Like, is this one of many different issues that has happened over time? Why are you refusing to get vaccinated? Is it because you've got maybe some medical issues? Maybe it's a religious belief, because that is now covered under the Human Rights Code. Your employer, to a certain extent, unless it's going to cause them extreme hardship, may have to actually accommodate your deciding against getting a vaccine in those circumstances. But so it's going to depend on a case-by-case basis. And it's one of those situations where, as it's happening, you really should reach out to a lawyer to consult, because we can kind of give you an idea of, you know, you are heading to a termination and there's a fair chance that this might be for cause, or, you know, you're well within your rights to be expressing your objections, but here are the risks to keep in mind. So it's something you want to get in communication with a lawyer about from the very get-go. And keep in mind, at the end of the day, we're dealing with a public health crisis pandemic. So and we're taking a lot of cues from the government as well on this. So at the end of the day, the employer is kind of given a bit of leeway with regards to these vaccine policies, because the idea is to try to keep the workplace as healthy and safe as possible for the greater mass, right? So I know that's not the ideal answer, the it depends kind of answer, but it will kind of depend on your employment history and why it is that you're refusing to get that vaccination.
So Simran, if an employer terminates you, and, you know, let's say following the question, the employer terminates you at, or, you know, around the time that you announce that you're not getting the COVID vaccine, but the employer, pays decides to pay the piper and give you your termination pay. Assuming in other words that the employer isn't firing you, for cause, does an employer then have the right to just fire you? And if the employer doesn't want to allege cause, in other words, can the employer
without termination without cause?
At any time, even if the unstated reason is that you're not getting the vaccine?
Yep. It's a great question. And honestly, I think the smarter employer is probably going to try to do that as opposed to go down the cause road. But at the end of the day, here's where you see the intersection between the pandemic and human rights as well. Because if you're refusing to get the vaccine and it's for a legitimate health reason or it's for a legitimate religious reason, the employer still, as under the Ontario Human Rights Code, has an obligation to accommodate. What we're seeing, though, and where the balance really comes in, is it's to a point of undue hardship. That's the human rights language. So the next question becomes, like, to what extent do they have to accommodate you? When does it become a health issue, a safety issue, or a cost issue for the employer that puts them at such an undue hardship that they don't really have to accommodate you anymore? So it'll really depend on the why. The why is always going to be the driving factor in this equation. But you bring up something that's interesting, because I've heard this happen more than once. What a lot of employers are doing is taking advantage of, there's currently an emergency regulation in place that allows employers to basically lay you off from your employment. Generally speaking, under the ESA, if you're going to temporarily lay someone off, there are very strict requirements you're going to have to meet, including how long you can do it for. And unless you and the employee have specifically agreed that we're going to be allowed to lay you off, as an example, if there's a shortage of work or whatever the case may be. Unless there is that consent, typically employers aren't allowed to just lay you off. At some point that gets interpreted as being a dismissal. But because of the pandemic and because it was putting employers in a really difficult position where at a certain point in time, you weren't even allowed to be in the workplace, we've seen this emergency regulation go into place. And according to that regulation, employers are allowed to lay you off without those strict provisions that are in place regularly under the ESA. So what we're seeing employers do is where an employee is saying, I don't want to come back, I don't want to get vaccinated, so I don't want to come back on that basis. They're saying, fine, we're going to lay you off and until, we'll reassess essentially at the time that the regulation lapses, or maybe at a later time when you've changed your mind or we've changed our mind. So they're kind of kicking the ball down the road to assess that question at a later point in time.
Mm-hmm.
I know that we had a related question that was really interesting as well. So if you
the opposite scenario.
Exactly. And it's funny because we're seeing questions on both ends of the spectrum here. So just to read it out loud, it says, I've been working from home since 2020, but we've been asked to return to work next month with no vaccine mandate. Can I refuse to go back to the office? And I'm going to say my favorite answer, it depends. So firstly, vaccine mandates are not illegal and they're not mandatory either. So while it's probably good practice for employers to have some kind of vaccine mandate, at the end of the day, not every employer has it. So it really depends on what the workplace is like, because under the Occupational Health and Safety Act, you're entitled to go to a workplace that you consider healthy and safe, and the employer has an obligation to maintain that, which is why a lot of them are trying to push for vaccinations of employees. So if there is a valid basis for you to be concerned because there is no vaccine mandate, and perhaps because the workplaces, there's no other precautions in the workplace, you may have some room here to say, I really don't feel comfortable going back in these circumstances. Interestingly enough, the Occupational Health and Safety Act allows for you to refuse, but what it provides for is that the employer needs to then look into your concerns and investigate. So it's not really a perfect fit for allowing you to refuse and stay at home. Mm-hmm. But what I would suggest again in this case is if there's something like this happening, be in touch with a lawyer. One thing you'll want to do is really position yourself to make sure that you are offering your employer alternatives to just saying, I'm refusing. Something like, I'm refusing, but I'm happy to continue to work from home. Or maybe there's a middle ground where there's masks, or you're given your own private office. And there are sometimes ways to come up with a resolution that addresses your safety concerns and also perhaps addresses what the employer is looking to do as well. So this is another circumstance where you should definitely be in touch with a lawyer early on to understand, because if it's a workplace where they're just letting anyone in, there's a high volume of people coming and going, and no mask mandate, no distancing mandates, like in that kind of scenario, especially where there's no vaccine mandate, you might have some options here to kind of push back a little.
When we talk about, you not feeling like your workplace is a healthy and safe environment, like what standard are we going by to judge that? Is it based on like what feels psychologically healthy for you as an employee? Are we going based on like some kind of objective standard about like what a public health guideline would say is like a safe workplace? Like how do we make that determination? That's
where it becomes like a gray area, because at the end of the day, it can't just be purely subjective. And I've got to confess, I don't know if the standard under the Occupational Health and Safety Act is objective or subjective, but it can't, in the context of COVID-19, my sense is the direction that we're going in is it can't just be a subjective concern. I think you're going to need to back that up with something a little bit more than just that. it can be like, look at it in conjecture with what your personal circumstances are. Are there health concerns that you have? Is there family members who are at a higher risk? What is the employer doing or not doing in the workplace? What's the kind of business that they're in? Is it just basically a private workplace that has no customers or clients? Do you have your own office? Are you sitting in a common space where people are coming and going? So I think it's not, a lot of us are going to have anxieties about being in any kind of public forum at this stage. And so my sense is it's going to need to be more than just that. It's going to, you're going to have to back it up with something more than that.
That makes sense.
It's an interesting time. So we might want to switch gears because we had so many estate related questions come in, and I know we put them together in a really interesting way. So
Yeah.
Joy, if you don't mind just rolling our next question.
Okay, so this is two questions in one, and I think that they're both really interesting, and I want to try to take them separately. What are the duties upon death of parents as their executor, and what is required to make the process smoother and easier? So when an executor, first of all, is the person who is in charge of managing the estate, which is, all of the property, including cash, assets, real estate, personal belongings that would have belonged to your parents after they passed away. Going along with that responsibility also often comes the responsibility to organize and pay for their funeral, organize and pay off any debts that they owe on their date of death. The executor is the person who's responsible for basically taking charge of all of the legal affairs of the person who's passed away, wrapping up all of the legal and sort of financial obligations that they owed during their lifetime, and if they had money that they left over, to distribute it to whoever is either named in a last will that they made, if they had a last will, or divide it up between their next of kin if they didn't make a last will. And so an executor will either be a person that the parent has named in their will, or if the parent didn't name somebody in their will, an executor can be any one of their children. And in the event that a parent dies in Ontario, any of the children who reside in Ontario and who are over the age of 18 would in theory be entitled to act as the executor of the estate. So if that's you, your responsibility as executor will definitely include things like paying off the debts of your parents that they owe at the end of their lifetime. They may not have any credit card debt, they may not have a mortgage in their name, but almost everybody has to file a final tax return in the year after they pass away. And there'll be, almost everybody will have a funeral of some kind, and there'll be funeral expenses to pay for. And then once the debts have been taken care of, at a bare minimum, if that person has property, you need to distribute the property to whoever it needs to be distributed to. If the parent has a last will, you'll divvy up their property in accordance with what it says in the will. If they don't have a last will, you'll divvy up their property in accordance with what the law in Ontario says happens when a person passes away without a last will and with surviving family members. That at a minimum, that is like the most basic rendering of what an executor has to do. Depending on how complex your parents' estate was, those basic responsibilities may break down into more complicated specific responsibilities. When it comes to debt, for instance, if your parents were involved in some sort of a lawsuit at the time that they died. Either they were being sued for money or they were suing somebody to get money. Your job as executor would be to take over that lawsuit and see it to its conclusion. If your parent owned a business, if your parent owned a business and the business didn't have its own succession plan for who takes it over in accordance with the business's articles of incorporation, you might be responsible for taking over that business and either making the decision to keep that business going or wrapping the business up, paying off any debts, taking any assets that the business owns, selling it and distributing it, either to the shareholders or to the parents, beneficiaries of their estates. If your parents owned a piece of property, you may be required to apply for what's called a certificate of appointment, which is a formal statement that is issued by the Court of Ontario that says such and such person is the official authorized representative of this dead person's estate, and anybody has the right to deal with that person and that person exclusively when they're dealing with the legal affairs of this estate. When you have that certificate in hand, what you can do is you can close or open bank accounts. You can sell your parents' property by transferring it from your parents' name into the name of their estate, the estate of Paul Adam instead of Paul Adam in my case. And then you could sell that property. And if your parents had investments or they had money that's in certain accounts, you'll be able with that certificate to close those accounts and distribute that money to the children, the next of kin. There may be other complex situations, like your parent who's passed away may owe financial support obligations to somebody, like an ex-spouse, or to a child who is still a minor, who is still being put through school. And so you may have a responsibility to fulfill your parents' financial support obligations after their death. Those are all just examples of things that an executor may have to do.
Is there also like tax obligations as well of some sort?
Yeah, an executor has to, at a minimum, like I said, file at least one tax return for the estate in the taxation year after the deceased passed away. If you sell, like I said, if the parent owns a business, you may have to file a tax return for that business. If you are selling property that belongs to your parents' estate, you may have to figure out how much you have to pay on that property in the way of capital gains. There may be something, there may not be a lot. And if you're applying to be formally appointed as the executor of the parent's estate, you may have to pay what's called an estate administration tax or a probate tax. And that's basically a tax on the value of the estate that you have to pay to the court in exchange for getting that little certificate, piece of paper that says that you're the authorized representative of the estate. So there are quite a few different tax obligations that you may have to take care of, which leads me into the second part of the question, which is what can you do to make this process simpler? The first thing is just bearing in mind as a general rule of thumb, being an executor, even for a really small estate, a so-called simple estate, is really complicated and really difficult. And it's a job that you have to do at a really emotionally difficult time in your life because you've just lost somebody that may be very close and very dear to you. That death may have been something that has been anticipated for a long time. If your parent was sick before they passed away, may have something that happened, very suddenly out of the blue. Either way, either scenario comes with its own challenges. But the things that I thought about that I think can make the process smoother I thought of basically four things. One, if there are other people who are beneficiaries of the estate, other people who are named in the will, or other, let's say siblings, or the surviving spouse of the parent who passed away, who are entitled to a share of the estate, and you're the executor in this situation, the number one thing I think that can make your life easier in terms of your obligation to deal with them and eventually give them their share of the estate is communicate with them a lot. Be really open and forthcoming about what phase of the process you are at and what you've already accomplished and what still needs to be done. If people are asking you for something like to see a copy of mom's last will, to the extent that you can, try to think about those questions from a neutral point of view. It may seem impertinent to you that this person is asking to see a copy of the will, a week or a month after mom has passed away. But, try to be accommodating of requests when you can be accommodating. If somebody wants to know how much the estate is worth, don't automatically jump to the conclusion that the person is being rude or looking for a cash grab. If somebody's a beneficiary of the estate, there's a very good chance that they have a right to know what the value of the estate is. And you should think really carefully before you refuse just requests for information, because often refusing a request for information can be the first start towards a conflict. The second thing I would say is, this goes hand in hand with communications, is manage expectations. Tell people that it is going to take a long time. Tell people that there are going to be taxes to pay, and that until every last drop of the deceased's taxes are paid, you're not going to be able to distribute every single asset in the estate, and that it's going to take time. Usually after a deceased person passes away, it takes at least a year for the final tax return to be filed before you can start distributing any assets of the estate. That's very not unusual. And managing people's expectations about, if there's a lawyer, how much the lawyer is going to cost, if it's going to take time for you to be formally appointed by the court as the executor or the estate trustee. Try to set their expectations about how long that's going to take. Don't let people get into their heads that, within a month or within 2 months, everything's going to be ready and their share of the estate is going to be headed their way in an envelope. The third thing I thought of is keep really good records right from the start. Anytime you spend money on behalf of the estate, keep a record of what you spent and keep a receipt. Anytime you pay somebody to do some work on behalf of the estate, keep a record of that. Whenever you close a bank account or sell an asset, keep a record of that asset. As soon as you're able to, try to take an inventory of everything that the deceased person owned. It's easy to keep records as you go, and it's really challenging to try to put those records together after the fact if somebody asks you for them. Just keep a running list of everything that you've done on behalf of the deceased person, every bill that you've paid, every time that you incurred a personal expense that you're planning on asking for reimbursement for later. And the last thing I would say is think really carefully about whether you might want to get some professional advice, like from a lawyer or from an accountant or from a real estate agent or an appraiser. Most of these expenses you can eventually, if not immediately, bill to the estate. If you have to pay for them out of pocket initially, you can usually get paid back. And if the if you're finding that no matter how hard you try, the process of being an executor just is not going very smoothly for you, not going very comfortably. There are just some people with expectations that are too big for you to manage all by yourself. And there are just tasks here like filing an extra tax return that's just too much for you to handle by yourself. Don't let yourself fall behind the 8 ball. Bring in somebody else who, for a reasonable fee, can help you do this work or do this work for you. And let the other people involved in the estate know that you're hiring a lawyer, which is entirely your prerogative. And it's not because you're planning on shortchanging them out of their share of the estate, or let them know it's not because you have something to hide and you need somebody to help you cover your butt. Just let them know that this is a lot of work and I can't do it all by myself. And I need some professional assistance. And you're totally within, and that I'm totally within my rights to do that. Would be my top tips.
I just ask a question though, because I think to myself, if I've been appointed as someone's executor, I'm overwhelmed thinking, how am I even going to know what they owned and what they owed? And is there a way to kind of make those inquiries, or is there like I guess a listing or an inventory of what they had?
That's such a good question. Whenever clients consult with me about, what else can I do in addition to making my last will, I always tell them, make a list of this stuff for exactly the reason that you just pointed out, because it can actually be really hard to find all of this stuff if you don't know where to look. If you're in a situation where you don't have that list handy, and you're trying to figure out where to look, just practical tips and suggestions. Figure out where your parent had a checking account and where they did their everyday accounting, and get copies of bank statements. Hopefully, if you're not sure where they did their banking, you'll at least be able to find their bank card. That bank card will lead you to what is hopefully their main checking account. That checking account will hopefully show you what bills they were paying out of that checking account, or if they had money that was coming into that checking account that they were then depositing in, let's say, a TFSA and RRSP. You'll be able to figure out what those were. If you see that there is a monthly payment to, Sun Life that may, or who does life insurance now? I don't know. State Farm, let's say. You'll be able to figure out where this person's maybe had a life insurance policy, and you'll figure out what that asset was. If the person had a relationship with somebody at their bank, or somebody at a private investment company, talk to their advisors. Their advisors may have taken notes from past conversations about, besides the assets that they were managing directly, what else they knew about what the deceased person had. And, again, if you have a good relationship with the other beneficiaries, don't be afraid to ask other people, hey, I'm trying to track down what all of Dad's assets were. This is the list of what I have so far. Am I missing anything? Do you know about any other assets that Dad had? Maybe it's worth considering trying to get help from the other beneficiaries instead of trying to keep all of the process like up in here and not letting anybody else in. If you don't have a very immediate specific sense that somebody is going to be looking to try to trip you up, if they sense that you don't know, if they get any sense in their head that you don't have all of the answers, use your brothers and sisters or aunts and uncles or the deceased spouse as a resource to help you do your job.
No, that's really good advice, because like you said, like it's already such a stressful time in itself to then have all this responsibility thrown on you to actually act in that capacity. The more help you can get, sometimes the better.
Yeah.
But I know we had one final question, and it was a really interesting one and definitely not an easy answer. It's, can I put any future inherited and other funds in a trust to secure from high conflict divorce? And its answer falls into both family law, and then Paul can definitely speak to the trust side of things.
Yeah.
What I will just mention off the top is, under the Family Law Act, any gifts or inheritances that you receive during the marriage, so after you're married, is actually already excluded from any kind of division or equalization. So just keep that in the back of your mind, is have you inherited these funds? Is it before the marriage, during the marriage, after the marriage? If it's after the marriage, it's not going to be subject to equalization in any case, because it's not a marital asset. It's something that occurred after the fact. During the marriage, it's excluded regardless. Before the marriage, that's when you may have that's where you may want to provide for something in those circumstances, because any appreciated value, if you've inherited something before the marriage and it then appreciates in value, that appreciated value is subject to being divided and equalized. So that's where you might want to, if you don't want that to happen, you've got the option of maybe doing a prenuptial agreement or a postnuptial agreement to specify that, we understand that this is what the Family Law Act requires, but we want to do things differently. But otherwise, it may not necessarily be as much of an issue as you'd imagine, because it's excluded regardless. The Family Law Act also provides that any income that you derive from a gift or an inheritance is also excluded property, but so long as the testator specifically provides for that. So in someone's will, they're going to have to say, I want, so-and-so to receive this, and I don't want their spouse to get any part of it either, like the income that grows on that. So that's kind of the family law perspective. Well,
Yeah. When we prepare last wills, it's a standard clause in a last will that we prepare, that we include in every one, a specific carve out, just like you mentioned, that if I am leaving any gift from my estate to a child or a beneficiary, and that person is later divorced or separated, that asset is not subject to division under the Family Law Act. And having put that in your will, as long as after you got that inheritance, you don't commingle it with any other asset that you own with your spouse. For example, Simran, you'll know more about this piece than I will, but like if, for example, you don't use it to buy the house that you then live in as your matrimonial home, if you don't put it into a joint savings account with your spouse, if you keep it in your own name, then it is generally excluded from those family law divisions.
I'm so glad you brought that up, because even within, like in the example that I gave, suppose you receive an inheritance before the marriage and it appreciates in value during the marriage. Actually, let me take that back. Assume you get an inheritance during the marriage, you put it in a joint account and you use it to pay all your household bills. You've now kind of commingled your funds, where you can't really say, are the funds that remain by the end of the marriage the same funds that were inherited, or money is coming in and going out, so what's actually the balance remaining on there? So it becomes very messy to try to deal with it. And if it goes into a matrimonial home, under the Family Law Act, the matrimonial home is given a very special status. So most people know this already, but regardless of who brings that house into the marriage, so I could have paid for all of it, brought it into the marriage, paid for it during the marriage, and even so, by the end of the marriage, my spouse will have an entitlement to half of that matrimonial home. And it's given that special status because the courts really understand that that is typically one of the more significant assets you're going to have during the course of your marriage. And while you may not necessarily be contributing financially, both spouses may be contributing in different ways, non-financially and financially, that they should get some recognition for. So for sure, I'm glad you brought that up. If you do need to be able to trace it in order to have that exclusion applied. I know the question also speaks to other funds that might be coming in. And under the Family Law Act, that is going to likely be subject to equalization, because the idea again is that you want both spouses to walk away from the marriage in equal positions. So you're each going to see changes in your finances from the beginning of the marriage to the end. And the party who has the bigger improvement would then pay the other a payment to equalize their positions. That's where that entire concept comes from. So if you're receiving other funds, I'm not quite sure if a trust will actually do very much to shield you from equalization, because at the end of the day, it's still a marital asset that's subject to being equalized. But you, in a case like that, where you're looking to say, I get that the Family Law Act will require us to divide and equalize, but I want to do something differently, that's where a domestic agreement may be very helpful. I mean, like a prenup or a postnup agreement that says, we kind of want to do things our own way, and this is what we agree we'll do.
Yeah. I'm every so often I'll get a question from a client who's preparing a last will, and they say, I have a kid, there's a divorce, or like, I don't trust this kid's spouse, and I have concerns about leaving something to them in the last will, and like if I die and they're in the middle of a divorce, that they kind of tiptoe around the question, but the real question is, the question that they're really trying to ask me is, what can I do to shield this asset from being part of my child's property calculation, that it would normally be under, that it would normally be, if it would normally be subject to being divided in a divorce. Like, I'm wondering, Simran, if you can speak a little bit to what your experience is with these cases.
It kind of depends, because yeah, like at the end of the day, if it's an inheritance or a gift that you're giving your adult child and you want to shield it from any possibility of equalization in the event of a separation, if it's occurring during the marriage, chances are it's probably going to be excluded property regardless. And you just want to be careful as the receiving party to ensure that you're keeping it, like you can account for it, you can trace it, down the road. And you're not putting it towards a matrimonial home, which then becomes its own, asset. So I don't necessarily know if it's as big of a concern if it's a proper inheritance during a marriage. If it's something that's occurring before the marriage, I would still say a prenuptial agreement that provides for that, that says, well, let me back that up by saying, remember, when you do your equalization calculation, you're only looking at how has my position changed during the course of the marriage. So right off the bat, you're getting that deduction for what you go into the marriage with. It's really more how much does it grow during the course of the marriage. And if you want to be absolutely sure that that's not going to be equalized, that, it's an asset that I received and it's growing because I received it as an inheritance, you should probably be doing that as a prenuptial agreement to say, anything in relation to this account is going to be excluded from any kind of equalization. We're not going to divide it in any way. That to me seems like a better way to deal with it. When you deal with trust, if it's intended to basically circumvent the Family Law Act, I can see that being very problematic. So I don't necessarily think that that would be the way to go about it.
The one other thought that I have about this, and this is more of a philosophical point than a legal one, but just if anybody's wondering about this, it's just food for thought. And this is an answer that I think is applicable to a lot of estates and, leaving a legacy type questions. You have a lot more flexibility with how you make gifts or dispositions of property to your children if you do it during your own lifetime. If you want to make a gift to a next of kin and you want it to get a certain treatment and you want to protect it in certain ways, there are a lot more ways that you can do that thoughtfully and systematically by doing it during your own lifetime, by creating an agreement with a lawyer and with your child's lawyer, by doing things like, you know, if you want to give them a very substantial amount of money to buy a house, many parents decide to do something like give their child an amount of money, but secure it with a mortgage on the house. That's not the right choice for everybody, but it's something that some people do. The sort of the point I'm trying to introduce is that you'll almost always have more options for how to deal with a question like this if it's your own estate that you're trying to pass on to the next generation, like on terms. If you do it during your own lifetime, then you will by leaving it to your executor to handle after you've passed away.
It's a good point, and I know we're at a time right now, but I guess I'll just maybe put this final question to you. If you're looking to kind of capitalize on just different advantages that are available now, who should you be working with? Like, who should you reach out to kind of figure out how to set up your this matter or your estate?
Well, I mean, Simran, this is something that you and I both work on a lot. So I think that a person should reach out to a lawyer, like one of us. A lot of times our clients, I have clients who come to me and say that they feel reassured working with somebody who is in their 30s because they know that if they were to pass away suddenly, the lawyer is still going to be around for a long time to help out with their children. And, you know, I hope they're right. But, you know, generally what we do is when you're helping somebody, I know when you're helping somebody plan a marriage contract, and when I'm helping somebody plan a last will, we don't just talk about like, okay, you're gonna name this person as a beneficiary and this person as an executor. I think we both try to, in our practices, sort of delve into not just the what, but the why of the document that we're preparing, and we try to address people's broader concerns. Like if somebody doesn't want any assets in their last will to fall into the hands of a certain child's spouse, you know, I'd always try to ask the questions of, you know, why is that? What are your real concerns here? Is there somebody else that you would rather see get the money instead, or are there certain terms that on which you don't want the spouse to be able to have the money? And then we're able to tailor a solution that's a little bit more exacting, and that, you know, either through the last will or through a different kind of agreement can help our client get a solution that's more than just what's going to be written in the out of the box paragraph that we include in every single standard last will.
Yeah, and I know just from working with you on some of these wills, it's also helpful to just have the connection with the lawyer saying, you know, this doesn't have to pass through your estate. These are the advantages of setting it up this way. And even putting you in touch with like financial planners and accountants and kind of having that dream team in place for what's going to work for you and your family. So I guess on that note, what I'll just mention is we do offer consultations. So if we haven't been able to get to your question today, you can always give us a call and we can kind of talk about it in more detail and, you know, more tailorized to whatever your question is. So just please don't hesitate. Thank you guys very much for taking the time to spend with us on Legally Adulting. It's always fun.
Thanks a lot, everybody.
See ya. Join us for Legally Adulting.
Adulting is not supposed to be easy.
what are the questions and concerns that we as young people have about living through a pandemic?